patent applications basically are, I mean, they are what they are, right? So it's an application you're applying to get something. So let's kind of take care of a few misnomers. So have you guys heard of provisional patent applications? Okay. So there's really three types, which I put up here. So a lot of times people hear about these provisional patent applications. And yes, it's true, it's a little bit cheaper to do, and it can make sense to do. What it's not, though, is it's never going to mature into a patent on its own. So a provisional patent application is used really in kind of two scenarios. One is you haven't fully developed your idea, but you have some special sauce, and you want to make sure it's protected. Because when you're dealing with patents, filing date is your best friend. So if you and I are both inventing something, never met, and we're inventing the same thing, but I file today and you file tomorrow, I win, okay? So, it depends on what you're inventing, depends on what you're dealing with, but what we see invariably is that when new ideas come out, for whatever reason, however the universe works, I don't know, but it comes to more than one person, generally speaking. So you see it in a lot of different industries, whether it's tech, whether it's pharmaceutical, whatever it may be. There always seems to be these little turning points where things come out. So if you look at these pharmaceutical companies, for example, which are one of the biggest utilizers of the patent system, they can literally come up with a new cancer drug or a new drug for Alzheimer's or whatever within days of each other. So filing becomes very important for them, right? So that filing date's very important. So provisional patents do give you a filing date, which is nice. They also give you a protection on the subject matter that you put in there. So if you've created something, but you're not fully, you know there's going to be different iterations of it, you just don't know where it's going to go. What a lot of these big companies do, and this doesn't make sense for a small business, but it makes sense for a large pharmaceutical company, every time they come up with a new special sauce, they file a provisional patent. So then they may consolidate at the end, they may wrap that all up into one non-provisional patent application, which actually gets filed to become a patent. Or they may discard some, or they may break that up into 2, 3, 4, 5 patents. It just depends. But it's all about preserving your filing date so you can go back to it. Now, when you file a provisional patent, you have 12 months to convert it to what's called a non-provisional. Okay? So filing provisional patents does not save money. It actually costs more money. But it does give you the benefit of having the filing date. It's cheaper to file a provisional than a non-provisional, but you have to file the non-provisional if you ever want to get a patent. So it's an add-on cost. The other reason some people do it, and I do advise it in some cases, is if you're looking to go out and raise money. So you have an idea, you've reduced it to practice, it's working, you want to file a provisional patent because you don't necessarily have the money, or you don't know if it's going to turn into anything. You may have a great idea, develop it, create it, and turn out no one wants to ever buy it. So, in that case, you don't want to necessarily spend a lot of money trying to get it off the ground if no one's interested. So provisionals have ability for that. So if you, within 6, 8 months, you're going to know the marketplace, you're going to know whether or not investors are going to be interested, so then file it. If not, and nothing comes of it, you've lost less money than if you would have filed a non-provisional. So those are some of the benefits of it. But the real crux of patent applications is in the non-provisional. So the non-provisional is your actual patent application. That's going to get looked at by the examiner at some point. Right now it's somewhere between 18 to 30 months, so there's a backlog. But it still preserves that filing date. So while you can't enforce anything until you get an issued patent, you can then go back to that date at that time. So you can put patent pending on a product at this point, so you can use it for marketing, so you can do things like that. So you're not stuck, if you will, once you file a patent. So I talked to a potential client last week, actually, and he's been fighting to try to get a patent. And he's years into this thing now for various reasons. There's some off-the-wall reasons that aren't terribly common, but we won't get into that. But the point being is that he hasn't spent one thought on trying to make the product yet. And I'm like, go to market. You're protected at this point. If you don't get a patent, you don't have a patent anyways. If you do get a patent, you're protected back to your original filing date. So start, producing your product or licensing it or trying to monetize it, because the clock's ticking. Because once you file, you have 20 years from that filing date. It doesn't matter when it's issued. There are a few exceptions that can get it extended, but for the most part, you have 20 years from that date. So if for some reason, for various reasons, you're in a fight with the patent office and you're up to 6, 7, 8 years for some reason before you get this patent issued, you've lost all that time. So you don't get the extension of that on the back end. So, it's important to start monetizing it once you file, in my view.